Hello friends, welcome to Master Mentor's YouTube channel. In this video, I am going to discuss details of the sedition law in India. The law of sedition has always been one of the most contentious topics in India. The views range from abolition of provisions from our law books to others demanding retaining sedition clause with more rigorous implementation. Many others have called for retaining the provisions but keeping its implementation within defined legal limits so as to strike the balance between national security and fundamental rights. The public debate over this issue was reignited last week when Chief Justice of India, Justice N.V. Ramanna, criticized the existence of law on sedition even after 75 years of country's independence. The sedition law is a colonial law, he said, while pointing out that it was used against freedom fighters like Mahatma Gandhi and Tilak. He said, "Is this law still required to exist?" The court was hearing a petition filed by an army veteran who has challenged the constitutional validity of Section 124A of the Indian Penal Code. Let us begin by going through the Section 124A of Indian Penal Code. Indian Penal Code is a law book which defines a crime and the punishment for the crime. It was introduced by British in 1860. Section 124A of the Indian Penal Code defines sedition as whoever by words, either spoken or written or by signs or by visible representation or otherwise, brings or attempts to bring into hatred or contempt or exercises or attempts to excite disaffection towards the government established by law in India, shall be punished with imprisonment for life, to which fine may be added, or with imprisonment which may be extended to 3 years, to which fine may be added, or with fine. Sedition in ordinary sense means stirring up rebellion against the government. Sedition includes all the acts and practices which have for their object to excite discontent or disaffection towards the constitution, the government or parliament, or to create a public disturbance or to lead to a civil war. And generally, all these endeavors are related to promoting public discord and disorder. In India, what constitutes sedition is highly debated. As per the Indian Penal Code, for an act to be called seditious, it should have the following components. First, any act which can be either written or spoken, or signs which include placards, posters, or any other form of visible representation. Second, must bring hatred, contempt, disaffection against the Indian government. And the third, it must result in imminent violence or public disorder. Now, after seeing the definition of sedition as per the IPC, let's move on to see the genesis of Section 124A of the IPC and its application in the penal pre-independent India. Many legal experts argue that the sedition clause is a vestige of British colonial rule, originally introduced to suppress critical voices emanating from the Indian freedom movement. Section 124A of the Indian Penal Code 1860, as we have today, was absent from the original draft of the Macaulay's IPC in 1860 and was only introduced in year 1870 by James Stephen. This version went through further modifications through the IPC Amendment Act 1898, and since then it has largely retained its form. The first notable case of the offence of sedition was reported in 1891 in the case of Queen Empress versus Joginder Chunder Bose and others. In this case, the editors of Bengal magazine were charged for their criticism of British government's policies, especially regarding the Age of Consent Act of 1891. But the next case has become the landmark of sedition cases in India. It was against Lokmanya Tilak in 1897. In this case, Bal Gangadhar Tilak was tried for sedition for alleged incitement through speech that led to the killing of 2 British officials. In this case, a single judge bench of Bombay High Court agreed with the definition of disaffection and opined that bad feelings towards the government is criminal, irrespective of the level of bad feeling. This way, the court virtually disallowed all legitimate criticism. It added that there need not be any material consequences at all to qualify the offence of sedition. The court held that in sedition matters, it is the intention of the offender which is of primacy and could be presumed based on the content, audience, and circumstances of their seditious speech. About 2 decades later, in 1917, Tilak was again tried for sedition. in a case for an article which he wrote where he had demanded the self-rule for the Indians. In the article, Tilak explicitly admitted his loyalty to British Crown but went on to criticize the civil services, arguing in court that the civil services and the British government were two distinct entities. A division bench of Bombay High Court rejected Tilak's contentions, holding that civil services derived their authority from the state itself and no such ground for distinction existed. The High Court, however, clarified only such criticism of civil services that can be attributed to the state should be considered seditious. But there was a difference in judgment of earlier sedition case against Tilak and this one. The court in this case took a relatively liberal stance, rejecting the interpretation of disaffection as done in the earlier case. This judgment had positive impact on free speech as the actual impact of the alleged seditious speech on the public was considered while reading the intention of the accused. Mahatma Gandhi was also charged with sedition. In 1922, Gandhiji was brought to court for his article in Young India magazine. While appearing in the court, Gandhiji famously denounced the law against sedition in court and referred section 124A as the prince among the political sections of the Indian Penal Code designed to suppress the liberty of the citizen. 3 charges were imposed on him: tampering with loyalty, shaking the mains, and attempt to excite disaffection towards the British government. With that history of sedition law in pre-independent India, let us move on to sedition law in independent India. Constituent Assembly debated section 124A's offensive nature and possibility that it will be used to jail government critics. Constitution makers understood the perils of making sedition a reasonable restriction on freedom of speech and expression under Article 13 of the Indian Constitution, of the draft Indian Constitution. The Constituent Assembly vigorously debated the offensive nature of this law and possibility that it will be misused to jail those critical of the government. On 1st December 1948, Congress leader and educationist K.M. Munshi said that there should be no room for sedition in independent India. He argued, "Now that we have a democratic government, a line must be drawn between criticism of government, which should be welcome, and incitement which would undermine the security or order on which civilized life is based, or which is calculated to overthrow the state. Therefore, the word sedition has been omitted. As a matter of fact, the essence of democracy is the criticism of government." While key founding leaders opposed the draconian law, the real credit of sedition not finding a place in constitution goes to Sikh leader Bhupinder Singh Mann. Mann, who represented East Punjab in the Constituent Assembly, made a case for upholding liberty and appealed to them to vote against embedding sedition into the constitution. Mann said he regarded freedom of speech and expression as the very life of the civil liberty. In 1950s, 3 important judgments were passed with regards to the sedition laws. These were Tara Singh Gopichand vs. State, Sabir Raja vs. State, and the Ram Nandan vs. State. The courts in first 2 cases believed section 124A of the Indian Penal Code had become void on the enforcement of the Constitution of India. It was Ram Nandan vs. State of UP, the first case to deal with the constitutionality of section 124A, where the Allahabad High Court held that section 124A of Indian Penal Code is ultra vires of Article 19(1) of the Constitution, both because it is not in the interest of the public order as well as because the restriction imposed thereby are not reasonable restrictions. This section is therefore not saved by the reservations contained in Article 19(1) of the Constitution and should be declared to be void. Soon after independence, India's first parliament passed the Constitution First Amendment Act of 1951, which among other things sought to resolve the anomaly in constitutionality of sedition law because of the Tara Singh Chand judgment. It did so by introducing new grounds on which the right to freedom of speech and expression should be reasonably restricted. In the original constitution, the only grounds for limiting free speech enumerated in Article 19(2) were the security of state, defamation, contempt of courts, and decency and morality. The Amendment Act introduced the new grounds of public order, relations with foreign state, and incitement to offense for restricting the freedom of speech and expression. Now, invocation to the offense of sedition was not confined merely to the acts undermining the security of the state or tending to overthrow the state. It merely had to be in the interest of the security of the state. Such wide-meaning terms gave greater discretion to state in invoking the offense of sedition. The amendment was put to test within 2 years in the case of Devi Soren and others versus the state, in which the accused, an Adivasi leader, was booked for inflammatory speech against the government. In its judgment, a division bench of Patna High Court made a clear distinction between disapprobation and disaffection and held that only disaffection leads to public disorder. The High Court also confirmed the constitutionality of Section 124A of IPC, ruling that it does not violate Article 19. The next is the landmark Kedarnath Singh judgment. Kedarnath Singh case of 1962 is considered as the most authoritative judgment of Supreme Court on the interpretation of sedition law. In this matter, a 5-judge constitutional bench of Supreme Court upheld the constitutional validity of Section 124A and went on to clarify the correct position of the sedition law in India. In this case, Kedarnath Singh, who was a member of Forward Communist Party of Bihar, was charged with sedition for making insulting speeches against the ruling Indian National Congress government. The Apex Court clarified that Section 124A could not be used to stifle free speech and could only be invoked if it could be proven that the seditious speech in question led to the incitement to violence or would result in public disorder. Since Kedarnath criticized the Congress party and not the Indian state, and the speech in question did not lead to any incitement to violence, therefore it did not amount to sedition. The court also noted that the presence of pernicious tendency to incite violence is precondition to invoke the sedition clause. Looking at the post-Kedarnath Singh developments, there was another important decision in the case of Balwant Singh versus State of Punjab of 1995. The accused here had been prosecuted for offence of sedition as he had engaged in sloganeering in favour of independent Sikh majority state in wake of Indira Gandhi's assassination. A 2-judge bench of the Supreme Court ruled in favour of the accused, on the rationale that since the speech in question did not lead to any disturbance of public order and was not likely to incite any violence in the minds of target audience, Balwant Singh's action therefore did not amount to sedition. Taking into consideration the phrase pernicious tendency discussed in Kedarnath Singh, the court stressed that such tendency was to be ascertained by looking at the consequences of the speech. Courts in recent times have relied on the above interpretations in cases of sedition with certain modifications. The Law Commission of India, in its consultation paper on sedition published on August 20, 2018, observed that whilst retaining the offence of sedition was essential to protect the national integrity, it should not be used as a tool to curb free speech. But before we move on to the Law Commission's report, let us discuss the debate of free speech and sedition. According to data from National Crime Records Bureau, there has been a significant increase in the number of cases filed under Section 124A, with such cases rising by 160% between 2016 and 19, while the conviction rate for such offences dropped from 33.3% to 3.3% for the same period. This clearly indicates that the state has been misusing this provision to file baseless or frivolous cases. Such abuse is bound to affect the free speech of citizens by forcing them to self-censor. To give voice to the importance of the freedom of speech, I would like to invoke here some of the statements by one of the great philosophers and political thinker, John Stuart Mill. John Stuart Mill argued that for stability of a society, one must not suppress the voice of the citizens, howsoever contrary it might be. In certain cases, to reach a point of right conclusion, debates and open public discussions are inevitable. Mill further advocated that a good government is one where the intelligence of the people is promoted. Democracy is not synonymous with majoritarianism. On the contrary, it is the system of inclusiveness where every voice is counted. In the words of Charles Bradlaugh, better a thousandfold abuse of free speech than denial of free speech. The abuse dies in a day, but the denial slays the life of the people and entombs the hope of the race. Observing that the criminality and morality do not coexist, the Supreme Court held that free flow of ideas in the society makes its citizens well informed, which in turn results in good governance. The relationship of Section 124A of the Indian Penal Code and Article 19 of the Constitution of India is a strained relationship. The Constitution of India guarantees freedom of speech and expression in Article 19(1)A, which provides that all citizens shall have the right to freedom of speech and expression. The Indian Supreme Court has held that freedom of expression under Article 19(1)A includes the right to seek and receive information, including information held by the public bodies. In the case of Tata Press Limited versus Mahanagar Telephone Nigam Limited and others, emphasizing the importance of freedom of speech, the Supreme Court observed, freedom of speech goes to the heart of the natural right of an organized freedom-loving society to impart and acquire information about that common interest. By Article 19(2), however, the constitutional right to freedom of expression is limited. The extent and scope of protection of free speech and expression in India is largely determined by interpretation of the terms "in the interest of" and the reasonable restrictions of the various grounds that are listed in Article 19(2). The Supreme Court decisions on the same, however, have been inconsistent. The court has interpreted in the phrase "in the interest of" in Section 19(2) broadly holding that speech that has a tendency to cause public disorder may be restricted even if there is no real risk of doing it so. The question whether Article 19(2) and Section 124A are contradictory or compatible to each other, there are three arguments that can be made for. First, Section 124A ultra-vires the Constitution since it infringes Article 19(1)A and it is not saved by expression in the interest of public order. Second, Section 124A is not void because the expression in the interest of public order has wider amplitude and is not confined to the violence. It must undermine the authority of the government by bringing in hatred or contempt or disaffection towards it. In Indramani Singh versus State of Manipur, it was held that Section 124A is partly void and partly valid. Exciting mere disaffection or attempting to cause disaffection is ultra-vires, but the restriction under Article 19(2) to excite hatred or contempt against the government established by law in India is valid. Third, the Indian Supreme Court has made it clear that only restriction in interest of one of the 8 specified interests can pass constitutional muster. In March 2015, in striking down Section 66A of the Information Technology Act, the Supreme Court ruled that any law seeking to impose a restriction on the freedom of speech can only pass muster if it is approximately related to any of the 8 subject matters set out in Article 19(2). Why does India need to scrap off the sedition law? The sedition law in India can be questioned for the following reason. First, it is a colonial law. British government used this law to suppress the rebellious criticism, speech and views against the British rule. But this colonial law is still being used in independent India despite having specialized laws to deal with the external and internal threats to sabotage the nation. Hence, in a democratic republic where the sovereignty rests with the citizens, such law have no significance. Second, in Parliament, the then Prime Minister Jawaharlal Nehru, while introducing the Constitution First Amendment Act of 1951, had identified offence of sedition being fundamentally unconstitutional, and he had remarked that, "Not so far as I am concerned, that particular section is highly objectionable and obnoxious, and it should have no place, both for practical and historical reasons, if you like, in any body of laws that we might pass. The sooner we get rid of it, the better. We might deal with that matter in other ways, in more limited ways, as every other country does, but that particular thing as it is should have no place, because all of us have had enough experience of it in variety of ways, and apart from logic of the situation, our urges are against it." Third, the sedition law and its misuse. The law of sedition is more likely to be the last refuge of the political parties, which they use for their own incentives. The party in government exploits these power against dissent, criticizing the functioning of government or questioning their policies. It is said so because the law has not yet been amended or repealed, despite the highest court of India has criticized law in several instances. And the last one, the crime of sedition is now dwindling in relevance. An examination of the Indian Penal Code demonstrates that its other provisions are sufficient to address all threats of violence and public order, rendering Section 124A absolute. With that, what can be done? Here we discuss some suggestions from various legal experts. First, all speech-related offences should be made non-cognizable and bailable offences so that there is at least a judicial check on the police authority acting based on politically motivated complaints. This would also reduce the harmful impact of using custody and arrest as the way of harnessing anyone exercising their rights of freedom of speech and expression under Article 19(1)(a). Second, all police departments must be instructed that decisions on whether not to arrest someone for speech should not be based on threats of violence or disorder by those who dislike or are somehow offended by that speech. Decisions to arrest someone for speech should be based solely on the evidentiary assessment of whether the individual has violated a law. Third, introduce educational programs for all police officers to ensure that they are fully aware of the limitations imposed by the Supreme Court on laws restricting freedom of speech. Pending repeal of amendment of Section 124A of the Indian Penal Code, police should be specifically informed that under applicable Supreme Court decisions, the sedition law is only applicable to speech that has tendency or intention of creating public disorder. Mere criticism of government or government policies cannot be basis of prosecution under Indian Penal Code Section 124A. Speech or expression perceived as disrespectful of India or its national symbols cannot alone be the basis of prosecution for sedition. Fourth, consistent with the guidelines accepted by the Bombay High Court, make it mandatory for police to obtain a legal opinion in writing along with reasons from the law officer of the district and from the state's public prosecutor before filing sedition charges. These suggestions, if applied, could go in a long way to protect the life and liberties of individuals while they are exercising their right of free speech and while expressing their dissent against the government. Now let us move on to the Opinion of Law Commission's report on sedition. The Law Commission was asked to consider Section 124A of the IPC. A consultation paper was released on the same to public opinion on August 30, 2018 to facilitate a wider discussion on the topic. There are 10 pertinent questions that the report states to try and ascertain the future of sedition law in India. Let us see each of them. First, the United Kingdom abolished sedition laws few years back, citing that the country did not want to be quoted as an example of using such draconian law. Given the fact that section itself was introduced by the British to use as a tool to oppress the Indians, how far it is justified to retain Section 124A in IPC? Should sedition be redefined in a country like India, the largest democracy of the world, considering that right to free speech and expression is the essential ingredient of democracy ensured as a fundamental right by our Constitution? Third, will it be worthwhile to think of an option of renaming the section with a suitable substitute for the term sedition and prescribe punishment accordingly? Fourth, what is the extent to which the citizens of our country may enjoy the right to offend? Fifth, at what point the right to offend would qualify as hate speech? Sixth, how to strike a balance between Section 124A and right to freedom of speech and expression? Seventh, since there are several statutes which take care of various acts which were earlier considered seditious, how far would keeping Section 124 in the IPC serve any purpose? Eighth, given the fact that all existing statutes cover the various offences against the individual and or the offences against the society, will reducing the rigor of Section 124A or repealing it be detrimental or beneficial to nation? And the second last, in a country where contempt of court invites penal action, should contempt against the government established by law not invite punishment? And the final one, what should be the possible safeguards to ensure that the Section 124A is not misused. The above questions have been presented in a hope that there may be scope for debate and discussion among the legal luminaries, lawmakers, government and non-governmental agencies, even with the academia, students, and above all, the general public so that we can have a public-friendly amendment in the Parliament. Against this backdrop, there is no doubt that the sedition law needs to be scrapped away. It has become a weapon to threaten anyone who speaks his mind or questions the government, and there is no place for it in the 21st century India. A Twitter post, a Facebook comment, or participating in a protest or a dissenting opinion is not sedition and should not be seen that as either. Attempts to stifle dissent and free speech aren't new. Former governments have booked activists and artists under the same law. Despite the constant demand for striking it off, the statute and mounting evidence of its misuse over the years, none of the governments have shown any willingness to repeal it. In past few years, we have witnessed many such instances as horrendous examples of authoritarian government stifling dissent on the grab of sedition. The word sedition is thus extremely nuanced and needs to be applied with caution. Since the law of sedition came into operation in 1870, it has continued to be used to stifle voices of dissent, protest or criticism of the government. While Indian courts have generally protected freedom of expression, their record is uneven. The equivocal invoking of the provision has put it in the question as well as the spotlight of media. Yet there has been no effort in respect to its possible repeal by the government. Well, that brings us to another remark made by CJI N.V. Ramanna. The CJI-led bench said its concern was the misuse of the law by the executive without any accountability. He said, "Use of sedition law is like giving a saw to the carpenter to cut a piece of wood, and he uses it to cut the entire forest." With that, I would like to end the discussion on the sedition law. Hope you have understood the topic. If you liked the video, do press the like button and share it with your friends. And please, for more videos and updates, do subscribe to our channel Master Mentors. Thank you and see you in the next video.